December 6th, and therefore they didn't have a chance to act upon them. And I come back to a very, very simple truth, which is, to me, in part what you said, was we owe it to the public. The public has every right, and the board has an obligation for board discussion and public review of contracts that are promising thousands and thousands and sometimes millions of dollars. And to omit that process, to me, is a complete disrespect and a dereliction of our duty. So I'm very concerned that we would, first of all, in the cure and correct, again, I'm going to say it again, it's not about determining there's a Brown Act violation here. We don't have to say there is or there isn't. You can, despite a citizen's complaint, take action. We could do it a year from now and take action and cure and correct, because we just are saying to the public we can do it better, and it's just doing it over. And yes, we could argue the legal merits. Unfortunately, none of us up here is an attorney, and we're not a court of law. The difference between a school board and a court of law is we don't have to make that finding. We can simply make a judgment that we want to do it better. And that's what I would highly suggest. That's why I'm suggesting it's pure and simple what it is we value. The question comes back around to why in the heck this process even ended up here. It ended up so badly done. And I go back to April 23rd when I was on the board and asked those questions on April 23rd. Is where are those new contracts? We're looking at old contracts. I asked again months later, what happened to those contracts? And people on this dais stared. No one responded to me when I asked months later, what happened to those contracts? Not a single response. Suddenly, these contracts are produced. And again, they're produced without board review and board discussion and public review. And there's another arguable point, and that is that on April 23rd, this board just entered into a verbal commitment. And I'm not saying anything about what we might do with these contracts. I'm talking about the simple process that we're being asked to correct. And it's a simple process over whether we want to do it better. On April 23rd, the board had those contracts on, had the language on the agenda that we would consider an extension, and that's what they did. But by contract and simple contract law, and people who go to law school, Ms. Cooksey, probably get it in the first week, written contracts can only be replaced by written contracts, not by verbal agreements. And there was only a verbal agreement on April 23rd to whether or not those would be extended. And the written contract was withheld. The written contract was withheld from the board for discussion, and the written contract was withheld from the public for review. So I maintain, irregardless of whether you think, we need to prove this is a Brown Act violation, this board can simply say on simple, plain, straightforward values, has nothing to do with the quality of the employees, it has nothing to do with the conditions of the contract except they're flawed, which would have been corrected in board discussion and public review. It has everything to do with whether we want to be open and do it better. And it was reprehensible that these contracts came forward on April 23rd, were rushed through. It was reprehensible that they were not returned at the next board meeting for discussion and review. And it was reprehensible that months later when I asked what happened to those contracts, no one responded to me. And it was reprehensible that they appeared in December without any warning that this was going to occur. So all of that, to me, it's more around, is this the kind of behavior we want to model for the public? And I myself say absolutely not. I say we absolutely want to be straightforward and open with the public. And the only way to do that in this case, to me, is to put those back on the agenda and cure and correct and reconsider the process that we used.
Madam President, because we're getting circular in our arguments on my amendment to the substitute motion, I move to close debate on the amendment to the substitute motion.
And Mrs. Mayor, you don't even need to move to close that, because I would say that we can close debate at this point. There's no problem with that. So I am closing debate at this point. I believe, because I tried on Monday night to allow people to speak far more than you're allowed to speak under parliamentary rule, but I felt it was important on Monday night that people have a chance. to go on with the discussion. But at this point, we've had plenty of meetings, plenty of time, and it comes down to a simple decision. So I would go back to whether or not we want to accept this motion as a substitute.
Well, first we have to vote on my amendment to the substitute motion, I believe.
Well, we haven't accepted your substitute motion, Mrs. Mayo.
I believe we amend, the substitute motion can be amended. You vote on the motions to amend the substitute motion. Then you can go through your process to either thumbs up or thumbs
Well,
down
we're not gonna do
on
that.
the amended substitute motion.
Okay, we have not accepted your substitute motion. Believe me, that is a step in there, and that's what Ms. Cooksy's seeing. If we want to take a vote on whether or not to amend the substitute motion, we can. But we have not accepted your substitute motion, and I'm gonna maintain that that is the procedure. You must accept a substitute motion, because I think it's important that we follow what is in Robert's rules, because that's what we've agreed to do. Ms. Cooksey wants to speak.
I might, if the board is sticking to the same amendment that Ms. Mayo made, not the new one tonight adding the Brown Act violations, but the old one that you made last week or last Monday, if you're sticking to that, then I don't agree that there needs to be an acceptance of that. There just needs to be a vote of that. If you're adding in the new language about Brown Act, that is actually an amendment, that's a substitute to your amendment, and then I think Ms. Hanson is right, we need to vote on that.
No, I'm amending my substitute motion.
That's what I'm talking about. Well, may I ask, maybe the board should just vote on the original substitute motion, what you had last week.
Well, because it has not been accepted.
And that doesn't need to be accepted by Robert's Rules of Order.
Well, actually it does. I will maintain it needs to be accepted. So, now that we're totally confused, because Ms. Demler's looking at me, it's a total confusion. Ms. Cooksey's suggesting we go back to the original substitute motion. I will maintain that we need to accept the substitute motion. It doesn't mean you're taking an opinion on it. It simply means you're deciding you want to vote on that substitute motion. And I'm sure this is, you know, it's so unfortunate. It's this kind of stilted procedure. Mrs. Demler, you have a comment, because you're definitely looking like that.
I thought a parliamentarian had a particular position, and they were the one, the final sort of arbiter that made the decision. And it seems like we go to the person who is has the back.
Parliamentarian, Ms. Cooksey?
I believe that's the role of the general counsel at a public board meeting. There is not a parliamentarian that has been elected by the board.
Yeah, because we've never had one.
Right, and so usually, and in most cases by default, it's the council who is present. In this case, it would be me because Mr. Rowland was in.
So, since Ms. Cooksey has given us her opinion on how we should follow, it would seem to me that that's what we should do, and not have you say, that's very nice, but that's not what we're gonna do. I mean, she is the parliamentarian, she is the one with a law background, and so could we possibly just follow her direction?
Well, first, Robert's Rules doesn't require a law background, it's just deadly stuff. So, I still go back to the, all right, let's let Mrs. Cooksey re-express her position. And that's, you know, to me, it's not life and death here, what we're doing. I think the point of it is, it's called a democracy, and we vote on motions. But what we're trying to do is be respectful of Robert's Rules and adhere to that, because that's what we've agreed to do.
If the board is merely going to use the substitute motion from last Monday that Ms. Mayo had presented, then there is no need for this board to vote on whether or not to accept her substitute motion. The board must act on this before it can do anything else. If you are going to accept Ms. Mayo's amendment to her substitute motion by adding the information about the Brown Act and determining that there's no violation, in my mind, you are right, and the board would need to accept that first